Today, we are ranking 8 issues, including laws as well as things that basically permeate the criminal justice system that every single person who owns a firearm needs to take into account. But not all 8 of these things are created equal. So we're going to be going through them. We're going to be going through jurors' views on gun laws, courts to include judges and prosecutors' views on gun laws, stand your ground and duty to retreat, the overall carry law strength of a particular jurisdiction, how difficult or easy it is to legally acquire a firearm, castle doctrine, constitutional carry, and shall issue/may issue. We're going through all these and rank ordering them, in my view, as quickly as we can. So guys, my name's Tom Grieve, criminal defense attorney, ex-state prosecutor. How bad is the average person hit and affected by these laws, and how important is it to have good ones in these particular categories? Let's get into it. So I want to start with one of my favorite issues, which is overall carry law strength. Now, we're going to be listing these on tier maker from S to D. S tier means that this is super, basically God tier important. And then we drop down to A, which is also super important, but just not quite. It doesn't have that extra. And then of course, B, C, D, and you get down to D and C, which really are not that important. Now, truthfully, of course, all of these are ultra important. I wouldn't be including them if they weren't. So just keep that in mind. But carry law strength has to go S tier. When we're talking about carry law strength, we're talking about what are the penalties if you miss a posted sign. In other words, if you accidentally carry into a restaurant, if you accidentally carry into a mall or something like that, a private property location. Is that a felony? Is that a ticket? Is that a crime other than a felony? In other words, a misdemeanor or something like that? What are the penalties? Do you have an option to remove yourself without any kind of penalties, as we do here in Wisconsin? So what's the force of law, if any, that's applied to those private property posting signs? What's the breadth of sensitive locations where you are? Is virtually everything a sensitive location, or very few things sensitive locations? And among other things, of course, we get to property inversion, like we see in some very anti-Second Amendment states that are out there, where instead of setting the needle for private property like malls, retail, all that kind of stuff as being lawful to carry a firearm into, unless they post that you cannot, in many of these anti-Second Amendment states, what we're seeing across the last year, covered extensively on our channel, is the fact that, look, they make it actually illegal to carry a firearm on private property unless they post that you're allowed to, sometimes including other people's homes. So I think carry law strength is an easy S tier for me. One that is not an S tier, and this is going to be controversial, castle doctrine. B tier. Stick with the whole video to see why, but really quickly, castle doctrine, of course, we're talking about typically property that you have to own, whether that's a home, an apartment, whether that's a business, or whether or not it is your automobile. Okay, sometimes there's exceptions in different states. Check your local listings. And generally, you have to be inside that location when someone breaks into or is in the process of breaking into one of those locations. And it will often create a presumption under the law that you're in fear for your life and that you're allowed to use deadly force, unless rebuttable evidence says otherwise. Like, for instance, the person surrenders or tries to escape, run away from you, right? The reason why castle doctrine only gets B tier for me is because there are more important laws that can supersede it. And also some states, like my home state of Wisconsin, has done a lot to actually erode castle doctrine through what we call jury instructions. I don't want to spend too much time here. Castle doctrine, super important, but not as important as some other laws yet to come. Let's also talk about constitutional carry. Constitutional carry is an issue that, of course, deals with the concept of no, you do not have to get a permit or a license to be allowed to carry in your particular state. The majority of states at this point are constitutional or permitless states where a qualified, law-abiding adult citizen can generally carry ordinary weapons to non-sensitive locations. So we're not talking about schools or things like that. Post offices, we're talking about non-sensitive locations. Although we'll see if the Supreme Court does something on post offices in the not too distant future. I only put it at B tier because, again, it's not as important as, for instance, overall carry law strength and all that kind of stuff, though it is certainly important. Keep in mind, constitutional carry can apply equally to open carry as well as concealed carry. It can be a big deal for hunters and those who enjoy the outdoors who may be more interested in carrying in an open carry, whether it's a chest or a hip location, in order to protect themselves against four-legged critters. Now, let's just round this out by talking about shall issue and may issue laws, which gets a C. The reason why this gets a C is because up until 2022, many states unfortunately had a may issue regime, meaning that even if you met all the objective criteria, they could still turn you down for subjective criteria. Okay. Since the U.S. Supreme Court Bruen decision, that's B-R-U-E-N for those of you riding your lawnmowers, may issue's done. We're now in shall issue, which took this as being a very, perhaps, maybe even an A tier issue down to a C tier issue. Now, there's still a lot more work that needs to be done in many of these states. Again, all 8 of these topics are important, but it just falls down to a C tier issue. Now, the shall issue, may issue also ties off in my mind a little bit with legally acquiring a firearm. Let me explain why. Legally acquiring a firearm goes into A tier for me. And we're talking about your state's or jurisdiction's private sales laws. Do you need to get a license like a firearm owner's identification card, i.e. FOID for those of you in Illinois, purchase limits, waiting periods, and so forth. I view this as more important than shall issue, may issue, but still related in this one key respect. If you're never allowed to purchase the firearm, then it doesn't matter how long you can wait. You can't get it if you can't get it. But the reason why this is not S tier and on the same category and the same wavelength as carry law strength, for instance, is the fact that assuming that there's not outright prohibitions, looking at you, California firearm roster, the vast majority of the time in someone's life, you will be in possession of that firearm, even if you have to go through a 1-day, 2-day, 7-day, 30-day waiting period with restrictions, which is absolutely unconstitutional, and I'm 100% against it. Let me be clear. But the simple fact of the matter is that if you do that at age 20, 30, or 40, you still have presumably 60, 70, 30, 20. You've got decades of carrying that firearm or other firearms in front of you as compared to the still unconstitutional burden and inconvenience put on you for waiting. That's the reason why it's not the same as the carry law strength, where you are stuck with those issues across space and time if you have a bad carry law. So legally acquiring a firearm goes into A, and that's also the reason why shall issue, may issue go down into C. Even if it takes your jurisdiction a while to get to you, you can eventually carry throughout a longer period of time, hopefully, in your long and happy, healthy life. That leaves us with 3 huge ones. What we've got left, of course, as you can see on your screen, jurors' views on gun laws, the court's views on gun laws, and stand your ground. Let's start with jurors' views on gun laws. This one's going into easy S tier. Super important stuff, because no matter how bad your state's gun laws are, the jury box is one of our last checks on your state legislature. So how a jury is going to be looking at things, what are their attitudes on self-defense, that's going to be a massive check on the government and everything that comes upstream of them. I can tell you as a practicing criminal defense attorney that if we're in a county where we think that we may not have maybe the best jury pool, that can absolutely impact the strategies, tactics, and decisions made in a case. So your particular location and your particular juror's views on Second Amendment, big deal. Likewise, court's views, to include both the judges and prosecutors, another S tier. The jury doesn't have to hear about it if the prosecutor decides not to charge it because they view it as a reasonable use of self-defense or maybe an unreasonable burden on your Second Amendment and declines to prosecute under an unconstitutional law. Same thing goes for the judge. The jury doesn't ever have to hear about it if the judge tosses it out. So before you ever get to the jury, you've got to get through both the prosecutor and the judge. And of course, upstream of that, you've got law enforcement as well, which I'm all lumping in under court's views here. So S tier, but maybe not quite as S tier if I were to rank order S tiers as juror views. And last, but far from least, to my mind, is stand your ground laws and duty to retreat laws. If you are in a duty to retreat jurisdiction, that is simply awful for not only the Second Amendment, but also for your reasonable ability to protect yourself and make reasonable decisions with use of force in split-second moments. Stand your ground is, without a doubt to my mind, the single best, most beneficial and empowering law for law-abiding armed citizens who are simply trying to stay alive in their communities when they're going about their day, when they're going about their business. And this is the reason why Castle Doctrine got knocked down as well. Because if you have a good, strong stand your ground law, that's in essence supersedes, depending upon how it's written sometimes, the Castle Doctrine law in your particular jurisdiction. Okay, because stand your ground can apply, depending upon how your laws are written, both inside and outside the homes and public locations, and generally any place where you have a lawful right to be. Again, how your stand your ground laws are written can be very, very critical as to whether or not your stand your ground laws are great in and of themselves or poor. If you want to see follow-up videos talking about kind of going into differences and distinctions between carry law strengths, what are good, bad issues to be looking at so you know how to rank your state, as well as stand your ground laws and all that other kind of stuff, let me know in the comment field below. Be happy to do this. If I were to rank order the S tiers for you, I would probably go carry law strength first, stand your ground second, courts then jurors, because at the end of the day, if everything's illegal everywhere, I don't want to be seeing good people go down in felonies because it was a felony for you to possess anything, anywhere, anytime. Stand your ground has to become quickly after that. And you can make an argument before it because obviously stand your ground goes towards laws such as homicide and manslaughter that can put you into prison for decades. Carry law strength, presumably less so, but it will impact a lot more people. And I think that's kind of the tit for tat, give and take. Then of course we had the earlier discussions about courts and jurors. What do you think? What did I get right? What did I get wrong? I think there's lots of opportunity and ground for reasonable minds to differ here. And I wanted to do this in part to get the conversation started. So I hope you enjoyed this. I look forward to seeing the discussion in the comment field below. Show your support for this video as well as the Second Amendment and stand your ground laws by hitting that like button. I appreciate you sticking around to the end. Don't forget about quote of the day. A quote today comes from C.S. Lewis, who said, "One of the most cowardly things ordinary people do is to shut their eyes to facts." Hopefully you enjoyed this video, and as always, I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.